Good evening, Bruce Barfield. Live in Country Club of the South, been a resident of Johns Creek my entire life. Well, excuse me, I'm fifth generation Atlantan, so I've been here a long time, so let's put it that way, leave it at that. I did not have plans to speak tonight, but I'm the current president of the Atlanta Athletic Club. Seeing how so many people really can talk about the Atlanta Athletic Club and what we do, our vision for that land and so forth, I'd just like to come speak on that behalf. Before I do, I just want to remind the city, I know you know this, but we are a partner to the city. In our strategic plan is a vision statement in there saying that we want to be a good neighbor to Johns Creek, and that includes you. And I think you all know that we work closely with you in terms of hosting meetings, using the Heisman Field for your events and so forth. We like that. We enjoy that. We applaud that, and we think it's fantastic. So in the naming rights for the PGA Championship we had in 2011, we used Johns Creek as a naming for all around the world. How many broadcasters around the world saw that? We don't know. Hundreds of millions of people saw that in Johns Creek, Georgia. Hopefully that put it on the map for us. The brand project that came up in 2012, I was sitting on the board. I was a rookie board member at the time, and we just came out through a tough economic recession, which I think everybody in this room would tell you that everybody suffered. We lost 15% of our membership. It was just tough economic times, and we had to look at doing something different. Was a proposal out there? Yes, it was out there. Do we regret it? Yes, we regret that. Would it have helped the club from a business standpoint? Yes, it would help the club. But it did not. It failed. And I think that last council meeting we spoke about that. Tim Benson, our current treasurer, said that it probably would not have passed the membership vote, and Tim's probably right. You know, it was just not the right thing to do, and thank goodness that didn't happen. We came out of it. Like most businesses, we climbed out of it, and we're doing okay now. So we don't have visions of that. I don't think it'll ever happen again. We do believe it's our land, and we'd like to have just our ask the city council is just let us work with you so that we can come up with some language that makes sense for both of us. Thank you.
Is it Baxter Russell?
Good evening, Mayor and Council. My name is Baxter Russell, 1230 Peachtree Street, Suite 1200, Atlanta, Georgia. I am with Pursley Freeze Torgrimson here on behalf of the Atlanta Athletic Club tonight. And I know you've heard our position before, and I just want to quickly summarize where we stand now. I obviously do not have the same personal connection that Bruce does, and to be able to explain the club's role in this community, but our perspective from just our property rights and the comprehensive plan change itself. So under the current plan, we have a distinctive area designation that permits us mixed-use commercial, small-scale commercial, office, and residential. And within that residential, it's also mixed-use residential. Now, I understand others' perspectives here tonight on what they think our property rights are, but this current comprehensive plan designation is very important, especially in Johns Creek, because the comprehensive plan is given so much value. And also because for zoning actions themselves, comprehensive plan consistency is required. So this distinctive area designation and the permitted uses within that designation are important to the club. So under the current draft update, this distinctive area designation, it's eliminated. And as we've heard, in fact, the current plan designates the Heisman Fields property as undeveloped. And as Bruce said, what we're really looking to do is maintain the status quo of our rights. To sit down with staff or with you and discuss a way to maintain the current mixed use and mixed use commercial permissions that we have through the comprehensive plan. And as I've heard someone say tonight, this is not a last minute request. This is not something that we're just bringing to you. We've been presenting letters to Planning Commission and to Council since April. So this is not something that should be new. But we are here tonight to request further discussions of this property and to just request that we maintain the rights that we currently hold in that property. Thank you.
Is yours.
Okay, we have some questions.
You may.
Ebert, can I ask you a couple questions? So we just heard testimony about zoning rights and about classification, right? So properties zoned AG1. Please explain to me, because it's not clear, if it said distinctive in the old plan, doesn't that equate to some of the conversations we've had on Medlock Bridge where we've had zoning cases come in, there are parcels zoned certain categories, yet the intention was mixed use. Is that what we're talking about in relation to the Heisman Field?
So I think Nancy and Royce Reinecke did a very eloquent job of trying to explain zoning versus future land use maps. So kudos to both of you. You got it. So now I just need to get 84,955 other people to understand it. The future land use map is just as it says in the very beginning of this document. It is a vision for the next 10 years of what the citizens of Johns Creek wants to see happen to the city in terms of its growth and its development. It does not endow any permitted rights to any properties. So if you have an AG1 or agricultural zoned property under the current zoning ordinance of the city, you're allowed to do certain things. You're allowed to have a pig farm there. You're allowed to have a produce stand there. You can build a single family dwelling. You can have a barn to house agricultural equipment. You can grow produce there. You can have other types of animals there, and that's your rights. And if you want to do anything more with that property, it would require you to come and seek a rezoning from the city. The future land use plan is just a vision. And even if it called out to be distinctive or transitional, it was saying at the point in time when that was drafted in 2008, we're not sure what's going to happen with these areas of the city. If you can recall, that comprehensive plan, the one that we currently have, has a number of areas designated throughout the city that were close to commercial areas or at major intersections. And the thought at that point in time was, well, maybe something more should happen here. We're not sure what that is. It might be a mix of uses. And so the plan laid out a whole bunch of possible sort of smorgasbord of things that could happen. But even that would require someone to bring it to the council, bring it to the planning commission, and make a specific case for, I would like to do X, Y, and Z. I'll give you a point in case, which was the zoning case that you just heard most recently, RZ-18-001, which was at the intersection of Bell Road and McGinnis Ferry. That is currently in a distinctive area. The area is currently looked at to be mixed use. And what you all approved a couple of weeks ago was a zoning case that allows 42 townhouse units and a small 6,000 plus square foot retail building with a little bit of office and a little bit of retail and restaurants. But that was a specific case that came to you before that land was zoned AG1. Now it specifically can do what you as a council have allowed it to do. If it wants to make any changes to it, it must also come back and ask for changes to that zoning. So the future land use map inside the comp plan does not endow anybody with any particular rights. It just makes suggestions of what the citizens would like to see.
So how long have properties in Johns Creek, whether we were Johns Creek or Fulton County, been encumbered or controlled by zoning?
From what I can tell, 1950 was when the Fulton County Planning Commission adopted its first zoning ordinance.
Interrupt real quick, just a point of order. Sorry, Stephanie. Do you agree with what she said? I'm asking our attorney that just to make sure that we're, official here. Do you agree with what she said?
I do agree.
Okay,
it's
thank
the
you.
definition.
Okay.
Are we allowed to ask questions of people who gave testimony?
Yes.
Mr. Baxter, can I ask you a couple questions for clarity?
You have to go to the microphone.
Sorry.
Yes,
Hi.
ma'am.
Hi. So my question to you is, you've said that you believe your property rights are being violated, the club says. Can you explain what you mean by that?
Sure. Because of the importance and the significance that Johns Creek places on the comprehensive plan in their zoning decisions, we view it as another step in the zoning process. The comprehensive plan, I do agree, it is a visionary document, a forward-looking document. But because of the tie-in that it has in this jurisdiction to zoning decisions themselves, that by taking away a characterization or a distinction in the comprehensive plan, that we are losing the ability to pursue certain zoning decisions or certain zoning rights.
So do you think that you're going to be denied the ability to file with community development and make a recommendation for a change of zoning from AG1 to mixed use? From the normal process? Do you think that's being denied?
No, I don't think that process is being blocked off to us, no.
And do you
But
think
it's putting up another roadblock that we would have to seek comprehensive or future land use change to correspond with that same zoning request.
But do you think that other property owners in the city of Johns Creek in the last 12 years who asked for property changes, say up and down 141, were denied the ability to make those requests and the council to vote on that?
I'm not aware of those situations, I'm sorry.
Because I know in many cases, exceptions were made to the comprehensive land use plan and zoning. So I'm really trying to wrap my arms around how, because I'm very concerned about property rights, and it's when you throw that around, if the club's property's been encumbered by zoning since 1950, right?
Yes,
then
ma'am.
that zoning has been in place, and the zoning process has been in place to be followed. And so the rights are dictated by that zoning process. So I'm really trying to understand why there's a belief that property rights are being denied, because due process is there, the zoning process is identified, the land use plan is there to, the zoning and the land use plan work together. And so
Sure.
I don't think anybody's trying to deny anybody any due process, due rights, and honestly, in my experience, not to be flippant, but it depends on your council makeup as to how they would vote, because people could easily do an exception. I've seen it done many times. I've seen many councils also say we're sticking to it solidly. So I understand that, but does the club think their rights were violated when that case came before council back, I don't know, was it 8 years ago, 2014? They all blur together, and was denied. Do they feel that their rights were violated at that time?
I'm not sure.
Because I'm pretty sure the residents, I wasn't on council then, but I was a resident, the residents' opposition to that was just that. Now, I can't speak for the council members who voted, but it was a concern about the increase in density and the traffic, and that was why they were very concerned. So was there a belief that rights were violated through that normal process from the club's perspective?
From the brand.
When that zoning case came before council, followed the normal process, they asked for mixed use and were denied. Do they feel that their rights were violated at that time?
I'm honestly not sure. I can't comment on that
Okay.
at that time.
Okay, all right. I was just trying to get clarity to understand, because when you say rights, I mean, our country was built on property rights, but when zoning's involved, of course, the rights have been, it's like living in an HOA. You have to conform to the rules that are there. So the comprehensive land use plan, it just isn't clear to me how that would be. That's all.
Our position is that because the comprehensive plan is so closely tied to the zoning rights that you've been discussing, that by removing or taking away in our case, a distinctive area in the comprehensive plan from this property that's so closely tied with the zoning of our property that
The two
would be
don't
a
match.
taking.
So the distinctive area being mixed use and being an AG1, the two don't go together today. So the two are at odds with each other. So if you're cleaning that up, you're just mirroring what exists there. That doesn't deny anybody from being able to ask for a change. But the two don't go together. And so we as a body can't through this process without you going through the normal land use process, change it to mixed use. So from a city's perspective, it makes sense to align them. Nothing's changing or being denied. And that's where I'm struggling because.
Well, but also as it currently stands, it's designated as undeveloped.
Right.
So we would.
But is it
Can I
developed?
ask you?
Does that matter?
No, that's not. That's, if you mind.
No,
So
go ahead.
It's not currently saying undeveloped. In fact, I was on the committee and we did take your piece of property very particular, and that was one of the things I wanted to. So we took that out. So that's no longer a part of that. It's not saying undeveloped. We left it as is, and you know what your current zoning for that piece of property is, which is what?
AG1?
AG1,
Correct.
yeah.
And so if you wanted to go build on there now, you could go build what? 1 unit per acre, correct?
Correct.
And if you wanted to put a mixed use, what would you have to do?
Seek a rezoning.
Correct. Which is, that's why I don't have a problem with this, because you'd have to do that anyway. And I think unfortunately the previous thing probably got the community involved and they're worried about it. But look, we want to be your neighbor. You're a great neighbor to us, and I think if you came with a reasonable plan and went to the community and said, "Hey, we want to work with you," I really believe they would be reasonable. And my personal belief is I think that could be something really special on that piece of property. That's my personal belief, but I'm here to represent the community and you guys. And I really tried to take that very seriously when we were rezoning this, or not rezoning because we weren't doing that. We tried to leave it as is because we didn't want to affect your property in a negative way. And I also didn't want to rezone your property through a comprehensive plan, which I didn't want to do that. That wasn't right either. I did listen to what the people said, and I think we're leaving it as is. And that's why I think some of the statements, it's not undeveloped, and when we eliminated distinctive, the distinctive really didn't mean anything. So, we're not, it is very important on both sides. I want to hear what the people say. That's who I represent. I try to do that. This comprehensive committee was they were very opinionated on that, but I think we really tried to balance that. Sharon, you can comment on that. I think there was a really attempt to be fair to you guys, and we would. And I think that if you ever guys wanted to do that, I don't think you're being harmed in any way. I hope not. And I think if you guys came up with a reasonable plan and worked with the community, I don't think there would be a problem. And
So let me try to help. Mayor?
Can I just
Yeah,
add
go
one
ahead.
thing first?
Yep.
Because I do want to clarify the record. So Bruce and Baxter, as you know, I'm the only person sitting at the dais who was sitting at the dais back when the first comprehensive plan was adopted. I think I can speak to my own intent because I'm pretty sure I know my own intent. And back then, the use of the term, and it was inarticulate and it was ambiguous, I would argue it was done that way by nature, was to recognize that we had a few large pallets of land left in the city that potentially could be developed in a way that would both protect that was around them but be different in some manner than what was around them. So to put Heisman Field in focus, it's clear that whatever would happen with Heisman Field to the extent that it changes from its current use, which I would argue is actually private recreation use, no different than what's on the other side of the street, because some of you may not know, there are actually athletic fields for the private use of the members of the club, and members use it for walking their dogs and other activities, I'm told. Anyways, should it develop different than that, first and foremost, the rights that you are conveyed, and that's clear by Georgia law, is you are conveyed the right to develop it equal to that is around it. And this property is unique in that what surrounds it is 100% residential, and it has a certain development pattern. And we know that to be between 1 and 2 units per acre. So that's a guarantee. That said, it's also a large enough palette that I believe, and counsel, I may vary from you all, I believe that in fact there is, and I'm going to use the term mix in quotes, not mix in the zoning context. There is a mix that could come there that would still protect Prestwick and Thornhill, and the 141 corridor, and potentially might be something other than single-family homes at a residential density of 1 to 2 units per acre. So what I would like to see is a recognition that no matter what, the neighborhoods must be protected, but recognize that on large pallets of land, and now it's even less than it was back then, but my meaning then and my meaning today is that we should be open to looking at, and I know by law we have to be, open to looking at a appropriate zoning. Now, for the lecture. Bruce, the apartment zoning was a huge mistake. It was a mistake to the members, although I can't speak to that. It was a mistake to the community, and unfortunately it has jaded everyone's view of what the intent of the AAC is. You all have been an incredible partner to the city of Johns Creek, and you've been an incredible community member. In fact, I am positive we wouldn't be what we are today and with the reputation we had if not for AAC. So I will acknowledge that immediately. But it is unfortunate that that fear that still pervades our community today from that case is making it very difficult for folks to trust in the intent. And then when the club came up last meeting and said we want mixed use, that makes it even more difficult, unfortunately, because it unfortunately strikes the most extreme version of what mixed use is in the minds of our community and just sort of creates that fear. I heard something very positive in your comments tonight, and that was, let's work together on some language. And I hope this council will be open to doing so. But we all have to be mindful of the most important thing, and that is, while you're on one side of the street, Prestwick and Thornhill and a bunch of residential communities and no commercial is on the other side of the street. And that's the big concern and balance that would have to be struck. So I remain open to that, but concerned.
So, Mayor, to that point, and following up on Mayor Pro Tem Saprowski's comments and your comments, Mayor, for the rest of the council, Mayor Pro Tem Saprowski, Mayor Bodker, and I got together on the phone yesterday and came up with some edits to the goals and objectives, which the first goal and the first objective, I think, gets to the point of what the athletic club representatives are talking about. So, under the strategy to protect and preserve the city's premier residential communities and enhance our overall quality of life, and I might comment to the council, what I handed out was both a red line of the goals and objectives as well as a clean copy, just in the event that the red line is not clear. The current strategy for protecting the city's premier residential communities states, in its current language, require underdeveloped parcels be developed with a similar residential density as the surrounding neighborhoods. And I think that's precisely what the athletic club is concerned about. So we've drafted a change that says it is expected that underdeveloped parcels will be developed with a similar residential density as the surrounding neighborhoods. For parcels designated in the 2008 CLUP as transitional/distinctive, the terms transitional distinctive were deemed ambiguous and indefinable and are therefore removed without prejudice, and the zoning on specific parcels remains unchanged. The city should remain mindful of what surrounds each parcel, and if a unique and beneficial development were to be submitted for rezoning, it would be considered. Now, there are other changes in the goals and objectives, but I think that's the one goal or one strategy that gets to the heart of what we've been talking about this evening. Go ahead, Mayor.
And that may, in fact, not come as far as you all have asked, but I want you to understand that at a minimum, this as a starting point represents exactly what you're already granted in the law. And it just simply restates that that term was really meaningless, and everyone has read into it, and it's unfortunate, I regret it today. They've read into it what they wanted to read into it. It really conveyed nothing. And the character area at the time really gave more credence, and because at that time you were in the Medlock Bridge character area, which really extended from the north to the south, and it sort of created this illusion that that was a commercial area. And I think we all could admit that when you get really past the Regal Shopping Center or past the Target Shopping Center on the other side, you've left the commercial behind, and you now move into an institutional use being the church, and then all residential for south of that. And so the attempt in this language was simply to restate for clarity that, hey, if you've got something that will really enhance this community but recognize the value of what's around you and protect it, let's talk. You have that right no matter what we do. And so I don't know if it addresses your concern. I don't know if the council will support it, but that was our attempt in providing this language.
So since I've got the floor, let me just address the other issues in the revised draft goals and objectives that have been handed out. The majority of the red line changes don't change the context or intent of the strategies. They're just there for clarity to make them more specific to what I think was the intent of the CAC. There are a couple, actually there's one other objective that was deleted, and that's concerning preserving golf facilities as natural resources. This is really an area that was of concern that it may not be the city's appropriate role. Therefore, we deleted that entire section dealing with preserving golfing facilities. However, you know, there are other places in the goals and objectives that encourage the preservation of large tracts of undeveloped land as natural resources, which could include the golf courses. I think the rest of the changes are, as I said, don't change the intent or the context of it. I think overall the CAC did an incredible job on a very complex task over a long time period. And I think these changes are not meant to diminish the great work of the CAC, but simply to address some of the concerns we've heard in public hearings and clarify the intent of what the CAC has already written.
I will make one comment, though, Steve, on that, because there are some changes that I think are important, and it goes under Goal 3 with protecting the city's natural environment and historic resources. And, you know, what the language said was, you know, revise existing, but what the purpose of some of the red lines you'll see in here, and I don't think Mama Nature's here, but it's instead of saying, hey, you got to do this, it's encourage and possibly look at our regulations on, say, tree cutting or making green space, and maybe providing a way to incent people if we want that to happen. Builders, give them an idea, come up with new regulations to incent them to be more green or less clear cutting, and that's the kind of things that I think are important in this, because we talk about stormwater, and if we found out tonight that that's going to be very expensive to do some of these stormwater regulations, but if we want that, we come up with a new way to develop some different regulations that would incent the builders to do that, if that's what we're looking for, rather than requiring or whatever. And I think those are important.
Yeah, it's a great point to highlight that one. Thank you.
And the third thing that I think is targeted in here is a recognition that we're looking for an alternate way to move around the city. And some have proffered that personal transportation units, some refer to them as golf carts, there are other versions of that, should be promoted within the city, and we attempted to do some red lines to make it very clear that that is a future goal, specifically to try to increase our ability to use those kinds of vehicles throughout the city, along with walking and safer pedestrian movement, which was related to the bridges. So, Council, certainly I would hope that you'll at least consider this or think about it, and certainly I know that Steve and Lenny and I would be happy to answer any questions, at least about our intent. But, Council, we were asking questions, and I don't want to distract from that because we have some guests here, and if you had any questions for those who gave testimony or our staff, please do continue that process.
So, Sharon, have you seen these changes? I know I had a conversation with you earlier.
Yes.
Okay, and are you comfortable with?
I am. I think, again, for the most part, it's a little bit of wordsmithing in terms of making sure we're not requiring as much as we are encouraging, and/or I do think the idea of providing incentives, because as you have pointed out, most of our stormwater solutions come with a price tag. Most of the time they are not less expensive but more expensive, and so to encourage people to take a look at that, sometimes also you need a carrot to do that.
And Lenny, one thing real quick, if I can say, so Sharon and I had a meeting with a prospective developer earlier today who potentially may invest in a shopping center in Johns Creek. And it's not uncommon for someone like that to come into the city and say, hey, what's your vision for this particular parcel? And we really didn't really talk about the vision because I think the vision will be determined when we pass this plan. But an interesting place the conversation went, and it kind of proves the point about incentives, is we said that this particular parcel where it was located was near a very sensitive area from an environment perspective within our city. And we could easily see that the community would probably be more supportive of anything that might change with that if the person were introducing better control of stormwater through pervious surfaces and things like that. And while the city currently can't mandate that, what was obvious by the reaction was, hey, if you create a reason for me to want to do that, I'm going to go off and do that because it makes good business sense for me potentially, and of course it potentially makes good sense to the community. That said, it's all got to be balanced. And I just think that when you force that on the development community as their only option, what you do is you drive that away. And if that's your intent, great. I mean, that can be your shill to make that happen.
I agree wholeheartedly. I just wanted to make one more comment, too, about the first one with the distinctive and transitional. I agreed to it, or I said I could support it because to me it didn't mean anything, and then today I backed off and said I'm out. But I kind of don't want to just put something in there for fluff, and I kind of looked at it from 2 points. I looked at it from when I was on the CAC and what the CAC committee wanted, and then I looked at it when I started thinking about it from a property rights perspective. I kind of changed my mind and said, hey, this could be different. So I think this language, it starts a conversation. It may not be perfect, and there may be different language, but it didn't change anything really from a perspective. It just basically says, hey, if you want to come back, we should look at anything and everything. And I think really, to me, it's being good neighbors means working with your neighbors. And I think if a plan comes up, and I wasn't really even thinking of the AAC property in this one because there's other properties that I think are equally important, and there's more than just one. But it comes back to, if we can work together as a community, and hopefully everyone is. I know in the AAC's place, most of you guys, a lot of you guys live here, so you are members of the community. But I think if we can just if everyone can come up with a plan together, I think that makes it a lot easier. And I know from working with the CAC members who were there, they're all very reasonable people, and they seem, very interested. So my always thing is start with those people because they're obviously influential in the community. So I'm okay with it. I mean, to me, it doesn't change. It didn't change anything really.
But I think it does. It does send an important message. One, you took off the word require when it says will be developed with a similar residential density. Says it's expected, but at the same time it states that if a unique and beneficial development were to be submitted, it would be considered by the council. Doesn't necessarily guarantee it'll be passed, but it will be considered. And I think that addresses the concerns that were expressed by the AAC representatives here tonight, and states the existing process that any zoning case will be considered by the council, but I think it puts a softer edge on the words that were already there.
So we're going to be given time to look at this, right? So
we have at least 2 weeks at a minimum.
Okay, so I looked at that one statement, and I understand the clarification of transitional and distinctive because of all the dialogue, but the last sentence to me seems we shouldn't put it there. I mean, by law, they have that right.
That's a zoning
and
ordinance.
To put it in there doesn't make sense because the council would. I mean, we can't sit here and tell you how we would vote on a potential zoning case.
Nor does it say that.
Right, but there's no reason to put it in there because in essence, I feel like it's stating something that by law is already there and is not relevant to the dialogue. And I don't want to set an expectation that leads someone later, 10 years down the line when they go to change it. Well, you said you'd hear us and then maybe change it because distinctive and transitional was only a dialogue. And so the more you put in writing, the more confusion there is. At the end of the day, the rights haven't changed, the laws are clear. And that one sentence I have issue with because in essence you're trying to say something that is by design law and rights within the zoning process.
So again,
that's my opinion.
I would love if better wording could be articulated, but again, my mission in my participation in this language again was to try to balance landowners' rights with surrounding property owners' rights. And again, There is no perfect balance to that, but I think we have to recognize that we have a few, very few, large pallets of land left in the city. And I think that by their nature, they are unique. Again, I'm going to be careful not to say transitional or distinctive. They are unique. And therefore, I believe that with a large pallet of land, there is a way, although I don't know it, and it's not my job to come up with it, it's just my job to judge it, at least while I'm on the council, to balance the surrounding property rights, those that are right there adjacent to it, and other parts of the parcel. And I don't want to use mixed because, again, mixed implies commercial. I want to try to just suggest, hey, go come up with something that'll knock our socks off. We'll know it when we see it. The community will know it when we see it. We're just open to hearing it. I don't want to say, hey, if you don't bring us 77 homes, that's the only thing we're going to talk about. And I would hope that Prestwick and Thornhill would feel the same way, that as long as their rights are protected, which by default, we can automatically zone it for just the same density. That's a legal zoning. The lawyers can fight us all day long, and unless we come up with something that was arbitrary and capricious in that conversation, we win. And the benefit goes to the government in that case. Any good zoning lawyer knows that. You're smiling, you know I'm right on that. So the reality is that's the starting point. That can also be the ending point. And I just think that it's important that we recognize we have partners in this. AAC is not the only one. Dagmar Sands collection of properties along State Bridge Road would be another one. And some of these others that eventually did get zoned. Dean Gardens in its time was one of those. Again, it didn't go commercial. It was never appropriate to go commercial. Anyways, that was the point. I'd love to see a better articulation of the language, but I also would like to see a better balancing of landowner rights and surrounding properties being protected. So, Council, I challenge you to not just throw it out because it's easy to, but to try to strike better language.
Well, I struggle with balancing because at the end of the day, property rights are individualized and you can't balance. They are what they are. And
but zoning is a process by which, council member, you are by default in the process. The whole process of the zoning process is to balance competing rights. It is by default to hear someone who says, I am challenged with my current use of my property and I want to change that and I want to balance that against those that are around me. You wouldn't have to have zoning cases if it was strictly based on individual rights because the guy next to him would basically get a veto vote.
But balancing makes it subjective, whereas the zoning map and the comprehensive land use plan, if married together, stand on their own, and you either choose to follow or make exceptions, and it's the exceptions that get us in trouble. So
all the more reason then to state intent up front. So if your intent is only to allow this to develop as 77 single-family homes, then we're good to go the way it is. I'm telling you that my intent is to be open to listening to a unique plan if one's presented.
By law, everyone is required as council members to follow the law, and that is always the intent. And if you state what your end game is ahead of time, then you violated that law. And by putting something in writing to define something for a handful of properties, then by its nature, in my opinion, you are now sectioning off and treating certain parcels with preference because you've stated something different. But if you just follow the law, you follow the law, and then sadly, it becomes council mix.
Councilmember Andres.
So that's my opinion.
Lenny, can I make
Yeah, go ahead.
So we've had many zoning cases here where certain members, and that mix of members changes from time to time, will say, I'm not going to support the zoning action because it's not consistent with the comprehensive land use plan. What this language is trying to do for council members that make up the council well beyond the terms of everybody that's sitting here is to not have that hard statement of require undeveloped parcels to be developed with similar to the surrounding neighborhoods, to provide that softer edge that doesn't necessarily say that doesn't necessarily prevent something else good for the city, beneficial to the city, beneficial to the surrounding neighborhood from being considered. So I think it's an important distinction, minor though it may be, particularly not for the 7 people sitting here, for those that may follow us in these seats.
I'm 100% with you in everything right up to the last sentence. The city should remain mindful of what surrounds each parcel, and if a unique and beneficial development were to be submitted for rezoning, it would be considered. That is in and of itself, by nature, the rules of the game. And if council members don't like the way the two are married because they're not, and there have been so many exceptions made that then create problems where you're now saying the precedent is set, that there's X number of density here, therefore you have to pass it here, even though it's not, that's when you run into trouble. So if the comprehensive land use plan, which is why I want to see the overlay for the zoning map, if the two are in alignment, then at that point it's easy, and then it comes down to council members' preference. But that's the law, and then it's the way the council's then told, well, you have to follow this way because legally we'll get sued. If you add the statement in here, you are creating preferential treatment for a handful.
No, you're not at all. Councilmember Andres, I talked to our attorney today about this, and this means nothing. I mean,
then why put it in there?
Well, that was my point.
Does it mean something to the landowners?
But
was
the
my point.
landowners know that they have
So we don't grind on this for infinitum. Let me just ask the council. While the wording may not be correct, is there consensus for any changes within Objective 1, the first strategy? If there's not, then we can end the conversation. If there is, then let's keep working on the language, not necessarily tonight, but we can continue to work on the language. Is there consensus around trying to strike a better balance with the wording?
I would like to not force a decision right now while the discussion is new for the council, unless you all want to. I think that more input needs to be made, but to rush to judgment to gather up 4 votes, I think is a mistake.
I'm sorry, I asked whether there's interest in
This was
discussing the
just
wording,
handed to
not
us.
approving this wording, for clarification. Is there consensus around continuing to discuss this wording?
Tonight or, yes, absolutely. I mean, we need to get the wording right.
That's 1.
Yes.
Yes.
Yes, great. 2. Is there objections to continuing the discussion on the wording?
Well, I'm kind of with the Reinekes on that. This has been this has been through a very iterative process, and we've had so many meetings now. And so when you come to a change like this, or on removing Objective 3, I just want to see the reasons why we're doing it. And so I get now that transitional and distinctive can't be operationally defined by anyone. So I would remove it. But why it came to this point, or why we're removing it now, is unbeknownst to me.
It was already removed.
Okay, so then we can say it, and I would keep Objective 1 as is then, and remove all that language because we've communicated that we remove those.
I'm open to looking at this, but I'm not compelled for us to have consensus tonight by any means.
Okay. Jay?
Well, looking at the the edited version, I believe it does have the offer the opportunity for future council or the landowners to be more flexible. I like the edited version.
Lenny?
So I'll go back to what it was. The original was just said require undeveloped or underdeveloped parcels to be developed with similar residential density as the surrounding neighborhoods.
Is your microphone on, Lenny?
I'm not looking to change the intent. That was the intent of the CAC.
Is your mic on, Lenny?
Oh, I'm sorry. The intent of the CAC was basically one. This one, it was wordsmithing a little bit, basically saying, hey, we'll look at your property if you come before us as zoning. So I have no problem with that because it's not changing anything. I am not looking to change the intent of that. But I am okay with saying I'll be flexible. If you come to me with a plan, I'll evaluate it fairly. And that's what all this says. So this is basically fluff, which is why I said, hey, why are we putting fluff in there? But if it means something to I talked to our attorney. He said it doesn't give anyone any more equal rights or anything like that. But if that makes the landowners, gives them a little comfort, I'm fine with that because it doesn't change anything. But I'm not looking to change the intent of that, I guess is what I'm saying.
So let's try to make it easy on the council. Bruce, my suggestion is not just you, but potentially get together with folks like Dagmar, and because they're in similar situations, albeit a little different because they're in more of a commercial node than you are. Get together with folks like the Reinekes and the community members that were there with very strong feelings about the original case. And sit down, have a discussion with our community quickly, and see if you all can strike a balance. We want to support our community, we want to support our partners, and we'd love it if they come together. And so make that plan come together and make it easy on us. What you've heard from this council is, hey, we want to work with both sides. So try to make that happen. That'd be great.